topic which is independence of judiciary. So कोई बता सकता है कि हम ये टॉपिक क्यों डिस्कस कर रहे हैं? Anyone has any idea why are we discussing this? कोई भी क्लू, एनी रफ आइडिया? So I have a bunch of news with me because of which we are discussing today, and this is also might be important for from your exam perspective as well. So इसमें कई सारे पैरामीटर्स हैं जो हमें समझना बहुत ज़रूरी है. So first of all हम समझते हैं कि हमारे कंट्री का गवर्नेंस कैसे काम करता है, राइट? So it is very important to understand that how there are different structures in the country. So one of the structure is judiciary, one of the structure is executive, and one of the structure is legislative. So these are the three basic structures we have in which our country is functioning. Now अब क्वेश्चन ये है कि क्या इनमें से कोई एक भी सेक्शन किसी दूसरे सेक्शन के इंडिपेंडेंस में काम कर सकता है क्या, राइट? सो द इम्पोर्टेंट पार्ट इज important part is that it is really crucial that ये तीनों सेगमेंट अपने अपने डिवीजन में काम करें और किसी और के डिवीजन में स्टेप इन ना करें. अगर ऐसा होता है तो फिर यहाँ पे प्रॉब्लम आती है कि एक ऑर्गन इज नॉट एबल टू वर्क प्रॉपरली. अब ऐसा क्यों? अगर मान के चलो कि जुडिशरी का काम है लॉ बनाना, ठीक है, सॉरी, जुडिशरी का काम है लॉ को रिव्यू करना, और जो पार्लियामेंट है उसका काम है लॉ बनाना, एग्जीक्यूटिव का काम है लॉ को एग्जीक्यूट करना. अब इस केस में अगर जुडिशरी घुस जाती है लॉ बनाने के लिए, राइट, तो दैट विल क्रिएट एन इशू बिकॉज दैट इज द टास्क ऑफ समवन एल्स एंड जुडिशरी शैल नॉट स्टेप इनटू इट. लाइकवाइज अगर पार्लियामेंट का काम है लॉ बनाना, तो पार्लियामेंट कैन नॉट डिसाइड हाउ लॉ विल बी, और is this a correct law for the public, or is this not violating the fundamental rights? So this is how different organs are there and they function. अब एक चीज और समझते हैं कि why judiciary wants independence. First, this is the primary question, why judiciary wants independence. Now the fact is that हम सबने सुना है कि जुडिशरी को हमेशा नॉन बायस होना चाहिए, जुडिशरी कभी भी बायस नहीं हो सकती. सो माय क्वेश्चन इज, क्या हमारी पार्लियामेंट बायस हो सकती है? क्या हमारे पॉलिटिशियंस बायस हो सकते हैं? क्या हमारे लेजिस्लेटर्स बायस हो सकते हैं? तो लेट्स से अगर वो लॉ बना रहे हैं, क्या वो XYZ रिलीजन के लिए लॉ बना सकते हैं? क्या वो XYZ कम्युनिटी के लिए लॉ बना सकते हैं? और स्पेसिफिकली हम अभी देख रहे हैं रिजर्वेशंस, राइट? रिजर्वेशंस आर गेटिंग इंक्रीज डे बाय डे. It started with 1951 और अभी तक आते आते we have crossed the limit of 50%, जो कि 1990s में इंदिरा साहनी जजमेंट में बोला गया था कि 50% लिमिट कैन नॉट बी ब्रीच्ड. अब क्वेश्चन ये है कि पार्लियामेंट ऐसे लॉज बनाती क्यों है जहां पे हमें जुडिशरी की जरूरत पड़े? बिकॉज हम एक डेमोक्रेटिक स्ट्रक्चर में हैं और इस डेमोक्रेटिक स्ट्रक्चर में पीपल सेलेक्ट द गवर्नमेंट एंड गवर्नमेंट टेक्निकली वर्क्स इन द फेवर ऑफ अ सिटीजन. नाउ जब इतना सिंक्रोनाइज सिस्टम है तो फिर हमें जुडिशरी में जाने की जरूरत क्यों पड़ रही है? तो द आंसर इज वेरी क्लियर कि हमें क्यों जुडिशरी में जाना पड़ रहा है, क्योंकि द पार्लियामेंट हु इज एंटाइटल्ड टू मेक लॉज इन द फेवर ऑफ द सिटीजंस, technically they are not making laws, or the laws which have been made is not being suited to the all the citizens, right? तो हर बार किसी को कुछ ना कुछ issues है और वो रहेगा, लेकिन the problem is that there are multiple areas where whole of the community has a problem. Maybe women in general are facing problem, maybe X religion is facing problem, maybe Y religion is facing problem, maybe poor are facing problem. तो हमारे लॉस कहीं ना कहीं बैलेंस नहीं है. अब यहीं पे जुडिशरी का रोल आता है कि दैट दे हैव टू लुक आफ्टर दिस. बट द सरप्राइजिंग क्वेश्चन स्टिल रिमेन द सेम कि क्यों हमारी पार्लियामेंट बायस्ड है? उसी के कारण जुडिशरी को अनबायस होना पड़ता है। अगर हमारी पार्लियामेंट ही अनबायस हो जाए तो जुडिशरी का आधा रोल वहीं खत्म हो जाएगा। तो जैसे कि मैंने बताया कि जुडिशरी का टास्क है लॉज को रिव्यू करना, राइट। अगर लॉज बनेंगे ही सही सेंस में तो रिव्यू करने का कोई सवाल ही नहीं उठता। So that is why it is really important that Parliament first of all make a correct law. So my question is still not answered. So if anyone of you have an answer, please let me know कि क्या हमारे parliamentarians bias हो सकते हैं, right? क्या वो bias हो सकते हैं और वो किस हद तक bias हो सकते हैं? So this is a very very primary question which you should think upon and at least give an answer. So So we have seen this trend that our parliament had been making laws which is not suiting to the different sort of communities. अब यहाँ पे जुडिशरी का रोल आता है। अब अगर जुडिशरी के पास भी फ्री हैंड नहीं है उन लॉज को रिव्यू करने का, तो दैट विल क्रिएट अ प्रॉब्लम, दैट विल क्रिएट एन इशू। अब हमने कई सारे इंस्टेंस देखे हैं, तो जैसे कि मैं बता रहा था कि मैंने कुछ न्यूज निकाल कर रखी हैं, तो जैसे वन ऑफ द न्यूज इज very recently, all of you must have seen this. So this says that Justice Abhijit Gangopadhyay announces resignation. Now why he announced resignation? Because he is planning to join some political party. So how far it is correct कि एक जज, वो भी हाई कोर्ट का जज, जजशिप को छोड़कर सीधे पॉलिटिकल पार्टी में आ रहा है? So it is very crucial that at least in judiciary to which we trust that they will help us out, now they are leaving the judgeship and they are going to the political party, right, which is a very surprising thing. And this particular instance in itself raised the question that is our judiciary independent? Why there are such circumstances because of which judges are thinking that political party is better than being a judge? The reasons are clear, so I'll tell you. there are there are certain things which defines the independence. तो कुछ बेसिक एलिमेंट्स होते हैं जिससे हम किसी की भी इंडिपेंडेंस को डिफाइन कर सकते हैं। और स्पेसिफिकली जब हम एक स्ट्रक्चर की बात करते हैं, तो फॉर एग्जांपल अब हम बात करते हैं जजेस की अपॉइंटमेंट की, कि जजेस अपॉइंट कैसे होते हैं, राइट। अब टेक्निकली अगर हम देखें तो यहाँ पे जजेस के अपॉइंटमेंट में कहीं ना कहीं मेजॉरिटी हाथ होता है पार्लियामेंट का। अब सिस्टम ये है कि हमारे पास एक कॉलेजियम सिस्टम है जो कि सुप्रीम कोर्ट बनाई है और ये आर्टिकल 124 ऑफ द कॉन्स्टिट्यूशन में दिया है। Now the biggest problem is even though the Supreme Court has an upper hand in deciding the judge under Article 124 of the Constitution, but they are legally bound to send the list of recommendation to the Parliament, whereas Law Minister will pass it to the Parliamentary Committee and thereafter it will be approved, which means that the collegium process is just an initial process, which further means that the deciding factor is not in the hand of Supreme Court alone. So technically अगर मुझे जज बनना है तो मुझे जज बनने के साथ some political connection is required because मेरा अप्रूवल पार्लियामेंट से आ रहा है। Likewise, if judge once you are into judgeship, आप जज के तौर पे अपॉइंट हो गए हो, there are further progressions, आपका ट्रांसफर, आपका प्रमोशन, right, many things are there. तो ये सारी चीजों में इनफैक्ट पर्क्स, हाउस, रिसेंटली लास्ट ईयर बॉम्बे हाई कोर्ट में दिस वाज एन इशू एंड इन मेनी ट्राइब्यूनल these are the issues जहाँ पे पार्लियामेंट ने, स्टेट पार्लियामेंट ने मना कर दिया, स्टेट लेजिस्लेचर ने मना कर दिया कि we cannot provide houses to the judges because we are in lack of such. तो हम आपको हाउस रेंट अलाउंस पे कर देंगे, आप अपना खुद का घर देख लो, which is a disrespect to a judge or to any government servant because you are at a very high position. So all of these things bounds a person to take another structure. So इसीलिए हमने देखा कि कलकत्ता हाई कोर्ट में this was the major improvement where a judge has left the judgeship, even being a high court judge, and joined the parliament, political party. अब यही चीज जब आप नीचे आते हैं तो आपको डिस्ट्रिक्ट कोर्ट में और बड़े लेवल पे दिखती है, बिकॉज देयर इज लॉट ऑफ प्रेशर, दे कैन नॉट राइट जजमेंट अकॉर्डिंग टू देयर ओन, Recently, Chandrachud went to multiple universities for the convocation program, and our Chief Justice of India has stressed this part a lot, that at least district judiciary need to work independently. They should give more bail orders, but their hands are being tied. So at the top level, we see that there might be a political interference, but on a lower level, we see that there is interference from the upper judiciary itself. So on district judiciary, there is both upper judiciary interference and there is a political interference. Definitely, कई सारे कई सारे केसेस में जब आप इनफैक्ट आप कोई भी मिनिस्टर को समन कर रहे हो, राइट, जैसे स्टेट के इंडिपेंडेंट चार्जेस होते हैं, तो अगर आपने मिनिस्टर को समन कर दिया, तो देन देयर आर मल्टीपल थ्रेट्स व्हिच जज हैव इन लाइफ. At least I have seen. So when you are pursuing law, you will go into the इंटर्नशिप्स. तो आप ऐसे कई सारे इंटर्नशिप्स करोगे जहां आपको डिस्ट्रिक्ट जज के अंदर या मे बी हाई कोर्ट जज के अंदर और इनफैक्ट सुप्रीम कोर्ट जज के अंदर काम करने को मिलेगा. इन सच experience, I have listened many stories where at least female judges have told that they are not free to give any sort of judgment. They have to be in their limits because they have to look after their family. So why this kind of fear is there in the minds of judge? And like this, many more are there. Maybe मेरा promotion नहीं होगा, maybe मेरे perks कम हो जाएंगे, maybe मुझे post retirement कुछ नहीं मिलेगा. So all of this concerns will force a judge to not work properly. And not this, there is another instance I'll show you. So surprisingly, in the meeting of International Court of Justice, so one of the Australian judges has applauded the Indian history, that how Indian Supreme Court, Indian court system, Indian judicial system have worked, all the progress so far. But in the country, we have seen that the scenario is absolutely different. So if we see there had been many cases. The very famous cases, इंदिरा गांधी वर्सेस राज नारायण. जब राज नारायण ने इंदिरा गांधी के अगेंस्ट केस फाइल किया था कि द इलेक्शन ऑफ द इंदिरा गांधी इज इनवैलिड, इट हैज टू बी डिक्लेयर्ड अनकॉन्स्टिट्यूशनल, एंड व्हेन द जजेस सपोर्ट राज नारायण, so we all know that the many judges were superseded and the third junior judge have been made the Chief Justice of India. So why so much political interference has been given towards the judiciary? This is still a question. So because of which there are post-retirement benefit. We have seen that Justice Gogoi accepted a candidature of Rajya Sabha. Then there are many judges who have become the chairman of many government bodies like National Human Rights Commission, right? Justice Mishra, right? Justice Mishra became the chairman of the National Human Rights Commission. So all of these things are worrying nature, that our judiciary is somehow getting diluted. Nonetheless, we have seen the duration of Chief Justice of India, Chandrachud, and he has changed a lot of things, but still there are a lot more to be done. So there are many more instances where government has oftentimes tried to control the salaries and allowance of the judges, and that has caused a lot of problem. So along with that, there has been multiple instances where judges have been bound to take up the petitions or reject the petitions. Specifically, आपको याद होगा कोविड के टाइम पे जब कई सारे माइग्रेंट वर्कर्स एक सिटी से दूसरी सिटी जा रहे थे, तब वहां पे अर्जेंट पिटिशन लगाई थी कि उनके लिए कुछ अरेंजमेंट्स करने हैं. तो बेसिकली कोर्ट हैज टू डायरेक्ट द सेंटर ऑफ द स्टेट गवर्नमेंट दैट दे शैल मेक अरेंजमेंट फॉर ऑल दोस माइग्रेंट वर्कर्स हु आर गोइंग फ्रॉम वन स्टेट टू अनदर, so that all the necessary arrangements can be made, food, shelter, water, all of this thing. But that petition was not being accepted for the urgent hearing. On the contrary, our very famous activist and author, and he's a news anchor, Arnab Goswami. So Arnab Goswami put up a petition for anticipatory bail, and that has been considered as a urgent hearing, which is in itself a contradictory. Many judgments have came which is by default favoring the political party. So why this kinds of judgments are popping up? Jammu and Kashmir internet shutdown issue, that issue remained for 6 months, which is very surprising because it is clearly violating the article 19(1)(a). So 1A talk about your freedom of speech and expression, and the right of internet comes into it, but for 6 months nobody checked. So in the case of Arundhati Roy versus Union of India, Supreme Court was entertaining this petition, but they took a lot of time. On the contrary, many judgments have came late into the night because there was a clear-cut involvement of the political parties into it. So this raised a very significant issue whether our judiciary is becoming biased towards maybe a particular religion or maybe particular political party or maybe towards a particular caste. So these are the different concerns which are popping up, and the solution which I believe at least is to give judiciary a real time independence, in the sense that at least salaries, allowance, perks, post retirement, all of this shall be fixed for the judges so that they should not feel insecure, right? We see that how many benefits a state government or a central government job has, or what benefits a minister has. Likewise, judges should also have a fixed sense of security. Along with it, we have seen Chandrachud saying that judges should be bold enough, courageous enough to take a stand. So many judgments we have seen, at least Chandrachud has given against the judge, against the government, be it central, be it or state government. So this is a very rigorous attitude which is required from judges to take ahead, which will help us to grow further. And the very I will conclude with this shocking point for all of you, which is a thought provoking. I would like you to think upon this, that we are living in a democratic structure, right? So as I mentioned in the beginning, that since we are living in a democratic structure, our main our main concern shall remain with the parliament. अगर parliament ने गलत law बनाया तो we shall be very much critical about, we should be very much reciprocative about the functioning of the government. We shall give our vote very seriously, right? So as I was discussing in a yesterday's session, that why the option of nota exists, why we are not sufficiently aware about the different agendas of the party, and why are we not making our decision a conscious decision. Because even if you choose nota, nonetheless a party will come, nonetheless a government will come, and when that government will make a law, we are the one who will suffer with that. So that is why it is a better option that we should become an informed citizen. So rather than understanding and changing the whole structure, we should try to make a small change, and that change will come from starting from ourselves. So we should become an informed citizen, we should read, we should see the history, the past of all the parliamentarians, all the legislators who are working, and their manifestos, that what all work they are going to do. So this is a better way that we shall reciprocate with our government, because government is meant for us, we are not meant for government, right? That's what Aristotle said in the jurisprudence, that let citizens submit their rights, submit their freedom, and in return the state will protect that. And surprisingly, that is not getting fulfilled, because state is the one who is violating our fundamental right. Why it has become a need that we need to protect part 3 of the constitution as a heart and soul of the constitution, so that parliament can never amend fundamental right. We have seen in the case of Keshwanand Bharti or Indira Gandhi or Minerva Mills and lot more. So why this need came? Because we were not confident enough कि हमारी parliamentarians हमारा fundamental right protect करेंगे. So this is such a hypocrisy, this is such an irony, that what we have made is ready to be break by our own parliamentarians. So with this, I will conclude. So if any one of you have any doubts, any comments, please let me know. Okay, fine. So thank you guys for joining, and see you in the next session.